Продовжуємо засідання.
Let's continue our official meeting.
Також у засіданні беруть участь члени Вищої кваліфікаційної комісії.
Members of the HUCJ Михайло Богоніць, Людмила Волкова, Віталій Гацелюк, Ярослав Дух, Роман Кадисюк, Надія Кобецька, Олег Колюш, Ігор Кушнір. Ігор Кушнір is not present. Руслан Мельник, Андрій Пасічник, Роман Сабаташ remotely, Сергій Чумак, Галина Шевчук are taking part in the meeting. I'm the chair, Андрій Пасічник. We have Katarina Doroshenko, secretary present. I'm announcing the items of our agenda. On compliance of candidates for the position of the judges of the High Anti-Corruption Court set with the criteria set out by Article 8 of the law on the Hague. Leonov no. Who is in favor of adoption of the agenda? Unanimously. The agenda has been adopted. Let's move on to the consideration of the first issue. Please invite Leonov Oleksandr into the meeting.
Добрий день.
Morning.
Розглядається питання щодо відповідності.
We are considering issue of compliance of candidate for the position of the judge of the High Anti-Corruption Court, Leonov Oleksandr Stepanovych, with the criteria set out by Part 4 of Article 8 of the law on the Hague. We have members of the PCAE present: Robert Broekhuysen, chair of the PCAE; Norman Aas, remotely; Mary K. Butler, remotely; Gabriela Yotkaida-Grodskiana, John J. O'Sullivan, Johnson Harlock Thompson. Members of the HQCJ of Ukraine present: Михайло Богоніць, Людмила Волкова, Віталій Гацелюк, Ярослав Дух, Роман Кадисюк, Надія Кобецька, Олег Колюш, Руслан Мельник, Андрій Пасічник, Роман Сабаташ remotely, Сергій Чумак, Галина Шевчук. You have the right to request recusal, to submit motions, to provide explanations upon permission of the chair, to express your positions and objections, and to challenge the decision of the commission. Do you have recusal requests? Please unmute yourself. Yes. And while answering the questions, please switch on your mic. No recusal request. Okay, thank you. The rapporteur is Kobetska Nadia Romanivna. Please, over to you. Thank you. General information about the competition and the participation of Leonov Oleksandr. With the decision of the HQCJ dated June 3rd of 2025, there was announced competition for the position of 23 vacant positions of judges of the High Anti-Corruption Court and Appellate Chamber of the High Anti-Corruption Court. By the established deadline, the Commission received an application from Leonov Oleksandr Stepanovych with a request to admit him to the competition. Technical break.
Продовжуємо засідання.
Let's continue our meeting. Due to technical problems, unfortunately, we did not have a recording of the previous part of the meeting. That's why I will repeat now the explanation of rights, and I will ask you again whether you have recusal requests. So we're considering the compliance of candidate for the position of the judge of the High Corruption Court, Leonov Oleksandr Stepanovych, with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the HUC. We have members of the PCA present: Robin Heinburg-Heisen, chair of the PCA, Norman As remotely, Mary Kay Butler remotely, Gabriela Yotka-Gritskiena, Georgia O'Sullivan, and Jessica Law Thompson. Members of the HQCJ present: Михайло Боганіс, Людмила Волкова, Віталій Гацелюк, Ярослав Дух, Роман Кодисюк, Надія Копецька, Олег Колюш, Руслан Мельник, Андрій Пасічник, Роман Сападаш remotely, Сергій Чумак, Галина Шевчук. You have the right to request recusals, to submit motions upon permission of the chair to express your positions and objections. Do you have any recusal requests? Right now, I do not have any recusal requests or motions. Okay. Over to you, Nadia Romanivna. With the decision of the HQCJ of Ukraine dated June 3rd of 2025, there was announced competition for filling in 23 vacant positions of judges of the High Corruption Court and Appellate Chamber of the High Corruption Court. By the established deadline, the Commission received an application from Leonov Oleksandr Stepanovych with on admission to the announced competition and conduct of the qualification exam with respect to him. With the decision of the Commission dated September 16 of 2025, candidates were admitted to the qualification evaluation and participation in the competition, including Leonov Oleksandr. With the decision of the Commission dated September 19 of 2025, there was appointed qualification evaluation of candidates within the framework of competition for vacant positions of judges in the High Anti-Corruption Court and Appellate Chamber of the High Anti-Corruption Court. For the decision of the Commission dated September 19 of 2025, there was appointed qualification exam, and the stages of its conduct were determined. With the decision of the Commission dated February 4 of 2026, general results of the first stage of the qualification exam were approved. Percent result of the qualification exam, Leonov got 321.08 points and was admitted to the second stage of the qualification evaluation. Some information about the candidate. In 2007, Leonov graduated from Odessa National Law Academy and obtained a specialist diploma on full legal education under legal sciences and obtained a lawyer's qualification. In 2009, he completed training in the Institute of Professional Judges Training at Odessa National Law Academy and got complete higher education. Professional activities of the candidate is the following. Since March 10 of 2004 until March 16 of 2007, Leonov worked at positions of legal counselor in LLC Skyhawk. Until March 19, 2007, until January 12, 2008, he worked in LLC Kulindrovsky Industrial Concern. From January of 2008 until March of 2008, he worked as a lawyer in LLC's High Call. From July 2nd of 2008 until June 15 of 2009, he worked as a lawyer in LLC Alpha Donetsk. From June 22nd of 2009 until July 16 of 2010, he worked as the judge's assistant in the Court of Appeal of the Donetsk region. From September 28 of 2010 until April 15 of 2011, he worked at the position of the specialist on problematic debt in J-Stock company, Укрсоцбанk. From April 16 of 2011 to September 30 of 2011, he worked as a specialist in the same Укрсоцбанk. From March 21st of 2012 until August 15 of 2012, he worked at the position of the specialist in problem debt management of Delta Bank. With the decree of the President of Ukraine dated July 31st of 2012, Leonov was appointed for the position of judge of Kirovsky District Court of Donetsk for 5 years. He took the judge's oath on December 19 of 2012. From August 16 of 2012 until March 2nd of 2015, Leonov worked at the position of the judge of Kirovsky District Court of Donetsk. With the decree of the President of Ukraine dated February 14 of 2015, Leonov was transferred to work as the judge of Malinovsky District Court of Odessa. Right now, that's called Hadjibaysky District Court of Odessa. According to the decree of the President of Malinovsky District Court of Odessa, dated March 3rd of 2015, Leonov was included into the staff of this court. Leonov's term of judicial powers expired in July of 2017. Accordingly, with the decision of the Commission dated February 1st of 2018, there was appointed qualification evaluation of judges of local and appellate courts for compliance with the held position, including Judge Leonov. With the decision of the panel of the Commission dated September 20 of 2018, Judge Leonov was recognized as compliant with the held position. With a decree of the President dated April 22nd of 2019, Leonov was appointed to the position of the judge of Malinovsky District Court of Odessa. Since then and until now, Leonov has been the judge of Malinovsky, as currently called Hadjibaysky District Court of Odessa. Leonov has professional experience at the position of judge of over 5 years. He took part in this competition under this criterion. He is fluent in the national language. He has submitted respective declaration of family ties, integrity declaration, and asset declaration. The Commission has sent requests to law enforcement and other bodies. We received responses which are available in the materials of the candidate's dossier. Thank you. Maybe you would like to add something to this basic information? No, thank you. Everything is correct. Okay, then. Thank you. Robert, over to you.
Thank you, Mr. Chair. I pass the floor to Gabriela, who's the rapporteur.
Thank you. So, hello, Mr. Oleksandr Stepanovych. It's nice to see you in this interview. And first of all, I would like to emphasize that all the questions which I will ask you are prepared leaning on your explanations provided for us in advance. So be very concise in answering them. But on the other hand, don't be afraid to repeat what you already wrote to us. And I also want to apologize in advance if I will stop or interrupt you, because we have strict time limits. And therefore, if you will go somewhere too far from the essence of the question, I will stop you and ask for clarification. This is suitable to you?
Okay. Yes.
Yes.
Thank you. So first of all, I would like to ask you several questions regarding your motivation. In your explanation, you said that state needs specialists capable to ensure a real rule of law. So explain, please, very briefly, how you understand the concept of rule of law in practical terms.
The concept of the rule of law in practical terms is realized by means of direct law application. Overall, I believe that that is one of the main principles of administration of justice and functioning of the state in general. Thank you.
Thank you. And what specific knowledge, skills, or professional qualities allow you to consider that you are such specialist that is capable to ensure this rule of law principle in practice?
Thank you for your question. I would like to point out that my professional experience as a judge is about 14 years now. Over this period of time, I have obtained lots of skills that, among other things, with the help of which I, in my work, realize this principle of the rule of law. First of all, these are such skills as strict adherence to the legislation and the absence of the violations of the legislation. That's management of the process in line with the procedure stipulated by the law. That's adherence to the rights and freedoms of citizens, bodies, and other organizations. That's how.
Thank you. So maybe you shortly can explain what experience do you have in handling corruption or corruption-related cases?
Дякую за запитання.
Thank you for your question. I would like to point out that I considered these categories of cases that are in the jurisdiction of general jurisdiction courts. That includes criminal cases related to corruption and corruption offenses. These are such corpus delicti as bribes, receipt of unlawful benefits, that is also abuse of power, embezzlement by a public official. About 50 verdicts have been adopted by me. In my experience, that is a general category of criminal cases that ended up with verdicts. Also, I did not have time to finalize some criminal cases, but in total, that's about 70-80 criminal cases that were considered by me. So I have some experience in this category. I was also an investigative judge, and I was monitoring adherence to the procedure during the pre-trial investigation stage by the investigation body. I also have more experience of considering civil cases, because once I was transferred to the city of Odessa, the meeting of judges.
Now I would like to ask you already second time apply for the high anti-corruption court position, yes? So, do you follow the recent case practice and court practice of high anti-corruption court?
Yes, of course, I am following that. And during the preparation for the written exam, I was also following the novelties that exist right now in the case law of the high anti-corruption court.
So maybe you can specify some novelties that are most interesting for you, for example?
The most active one that is being discussed now, that is the application of amendments to the criminal code and criminal procedure code related to conclusion of plea deals, the pre-trial or trial stages. And accordingly, the High Anti-Corruption Court, contrary to other courts that are also considering corruption offenses, have some powers regarding the approval of the plea deal without appointment of the real sentence, but rather by replacing it with a fine. That is the law dated 2024, and that is the most widely discussed that we have with respect to novelties.
Thank you. So I would like to proceed to another part of question related to the full access to the register of court decisions. You made several explanations about that. So first of all, I would like to ask, for example, in first round of explanation, you stated that you used the full access to the Unified State Register of Court Decisions exclusively for official purposes and never for personal needs. Do you confirm this statement? Yes or no?
Yes, I confirm this. And furthermore, I provided explanation regarding this.
At the same time, in 2026, in February, you submitted a memo to the court administration requesting an internal investigation into possible unauthorized use of your account. Explain what prompted you to do so, and what information did you have at this time that made you believe that your credentials were used unlawfully to go into this register? Very briefly.
Дякую за запитання.
Thank you for this question.
Питання, яке зараз
Yes, indeed, this is a question that
багато уваги, тому що до цього питання після того, як
requires a lot of attention from me. So after I got the PCIe request regarding a potential unauthorized use of my account by third parties,
зателефонував
I called
судових систем і запросив
the appropriate department in order to check whether they have any information
як було зазначено в
regarding the use of my full access and its use for more than 1,000 times. Because this is an anomalous case when someone made the search or used the access for more than 1,000 times. I was informed that I have benefited from full access for some time, and from 2025 that full access was restrained in order to clarify who had made those 1,000 searches, and I initiated a check and also turned to law enforcement, because in the further requests you gave me the names of the individuals regarding whom the searches were done, then telephone numbers and car numbers. So I transmitted that to law enforcement to make sure they can establish the facts who could use my account. So I turned to...
I would like to emphasize that you reacted in such a way to the general question about do you use this register for your daily work. So only after the date that you applied to your administration, we formulated the question in relation to concrete members and persons. So the general question raised doubts for you, and you applied to the administration just to check this situation?
В особистих цілях я його не використовую лише
So I don't use my account for personal reasons, only for my professional reasons. And when you asked for information regarding my wife, who is also an attorney, I explained to you that I sometimes use this access to avoid a conflict of interest. My wife is a practicing lawyer. That makes it more relevant, and I have never even searched information regarding myself in the register, because that risks may arise, that the conflict of interest may arise in that case.
Yes, and this is also a very strange situation that you reveal step by step all the information. Firstly, you said that you are using it only for personal, not personal only for official needs. In the second round of question, you said that you searched for your wife, and afterwards, already in third round, you said that maybe you already also searched for mother and for your brother. So how can you explain such situation?
Щодо дружини, я пояснив, оскільки вона
Well, as I said, my wife is a practicing lawyer, so I could do that to avoid conflict of interest. Regarding my mother, I could explain it by the fact that
відповідно в реєстрі ви також наводили практику
you
судову, де
also
моя мати є
stated
стороною у певних справах.
the facts
Для запобігання
when there were cases where my mother was a party to the case
пов'язані з цими справами випадки, я
and
робив
there was an appropriate relevant case law that I wanted to analyze. And regarding my brother,
хочу пояснити наступне.
I'd like to explain the following.
В певний проміжок часу у мене
Within a certain period of time,
знаходилось
I was considering
справ
about 5 cases regarding
власності на
ownership
самостійно збудовані
rights
об'єкти на
to
території Одеського аеропорту.
constructions
Наша юрисдикція.
on the territory of Odessa port, unauthorized constructions.
Об'єкти побудували правоохоронні
And those constructions
правоохоронних органів.
were built by law enforcement officials. And as I was considering those cases,
Кримінальне провадження і
a criminal case was started against my brother. He is also
метою
a government official,
це певним
and I needed to understand whether it was a kind of pressure against me. So I indeed made a search
ці
in order to
правоохоронці, які здійснювали
clarify
судове розслідування відносно мого брата, є тими ж самими
whether
особами, які
the law enforcement doing pre-trial against my brother are the ones filing the claims,
ця ситуація з братом
and whether I am considering their case. And all those 5 cases, 5 claims were withdrawn after I made that search. So it could be not random.
Pressure you were concerned about, and on what grounds you believe that such pressure can be made on you?
Я досліджував це питання з можливістю
So I studied this issue in order to be able to factor out pressure in the civil cases regarding unauthorized constructions built in the territory of Odessa seaport by law enforcement or ex-law enforcement officials.
But you mean you considered that maybe some pressure will be made for you in the considering such cases? About what pressure are you talking about?
Я мав виключити будь-який тиск, пов'язаний
I
з
needed to
тому,
factor out any type of pressure, including the pressure through family members.
Thank you for your answer. And now I would like to clarify, you said that there was a criminal case against your brother. Could you explain what exactly he was accused of?
Відповідно, він спочатку був свідком, а
So
потім
first he was a witness, and then he became a suspect. Article 368, getting an unlawful benefit by a government official. Later on, that case was transferred to court. It was closed in pre-trial, and the Supreme Court, it reached the Supreme Court. The Supreme Court decided that there were no grounds to charge my brother.
Also, regarding the search, why you searched the database using the case number or not the surname and name of your brother?
За номерами, я вибачаюсь, чого?
You used for the search case number, not the name and surname of your brother. In sometimes name and surname of brother, sometimes the case number. What is the difference? Why do you use these different methods?
А я предположив, що, можливо,
So I assumed
посадові особи правоохоронних органів,
that,
які здійснюють досудове
law enforcement officials doing the pretrial in that case could also be the parties to the civil cases on unauthorized constructions that I considered as a judge.
Саме я зазначив номер.
And I stated the case number.
Thank you. Also, regarding this search, I would like to ask about the Violeta Marova. You searched regarding her approximately many times, and you said that you never met her, you never communicated with her, but in the register there are a case in which the notary Violeta Marova was a participant. How do you explain such circumstances?
Дійсно, після того, як я отримав ваш запит, я
Yes, indeed, after I got your request, I Googled this name and surname,
дізнався, що Амарова
and I learned that Amarova Violeta is a notary
в Одесі.
in Odessa, and she may have participated as a third party in a case, but she never turned up in court. I don't know her personally. I have never met her, and I don't know whether that case where she was a party was during the time when I was the judge, but I haven't met her. And then on the website of the judicial branch, I searched for the cases in public domain, and I found that Tamarova Violeta, that you state in your request, was a Musayev Aldar's wife, and a different person, a different attorney represented the client. So I assumed that that information could relate to that client from that list, who also carried out searches regarding himself. And I'm not justifying myself. In any case, I didn't know those people, but the full access and my credentials is a matter of my reputation and integrity, so I need to understand who used my name in order to make searches.
The last question from this part is regarding Mr. Mamedov Gundus Aidinovich. Are you acquainted with this person?
Перепрошую, чи можете ви ще раз?
Could you repeat the name, please?
Mamedov Gundus Aidinovich.
Я Мамедова особа мені невідома.
I don't know this person. I don't know who that is.
From your IP address from which you search for your brother, you also accessed the decision and even closed one regarding this person. How can you explain this?
Цього приводу в мене пояснення такі, що цю особу я не знаю. І,
So I don't know this person. The only thing that I can explain, it may happen to you too that so it may have been a party in some case over these 10 years, maybe an episodic case, but the specificity of our work is that you take a case home and you check some info regarding a case. So maybe you could provide some additional information for me in order to understand this better.
we will discuss this if we need some additional round of questions. Now, I would like to go to further questions. And first of all, I would like to clarify whether you prepared the explanations, all three rounds submitted to us by yourself.
Я вам скажу, як я готував, якщо хочете
Well,
механізм.
I will tell you how I did it.
Not by yourself.
За допомогою своїх знань, в тому числі пов'язаних з роботою з
So in order to, I used the internet to brush up my knowledge, but I did it myself on my own. Other people didn't help me.
Information using internet, but everything you put together by yourself in the answers.
Компонував особисто я ці відповіді інформацію.
Yes, I prepared my explanations myself. I used the internet for some consultations, and my relatives helped me.
Yes. Why I am asking, because we find rather a lot of contradictions in these explanations, and therefore I just wanted to clarify if you confirm that you prepared by yourself, maybe using ChatGPT or some AI tools.
Я використовував
I used Google Gemini to do some calculations, because you gave me some criteria to do those calculations, mathematical. And so I used that mathematical model, Google Gemini, one of AI tools. I did use it in order to do it.
First block of questions is related to your apartment in Odessa of 69 square meters. In 2018, you acquired this property to the unfinished apartments, and it was valued approximately in 81,000 United States dollars. Do you confirm this?
Ні, дозвольте я
No, let me explain.
Just yes and no. Just this is simple question. Do you?
Це майнові права, які
So
були.
this is a new ownership right that I acquired with on an installment plan. I didn't pay them 81,000. I did quarter payments.
Yes. So you made 15 quarterly payments, according to your explanation.
Ні, я надав
Not exactly.
копії.
I provided all the copies of receipts of payment. There are about 30 payments. I made small payments, and within our payment plan, we did have 15 payments, but I failed to observe this plan. I stopped my payments in 2022 after the full-scale invasion, and that company stopped constructing, and I stopped paying following the timetable. So I haven't paid about half of the sum.
So we now receive another new information. In your explanations, you said that we understand that you said that you paid full sum because afterwards you transferred the rights of ownership to the third party, and now you said that you stopped paying and paid only half of the sum. Which answer is correct?
Дозвольте. Дякую за запитання. Я
Thank you
можу
for your
пояснити.
question. I can explain. So the first installment that I made, it was 10%, $8,200
З періоду з 19
Uh,
року по 2020
in 2019. From 2019 to 2022, I also paid.
Здійснив декілька платежів, ну не декілька, я надав
I made a
квитанції,
few
там,
payments
близько
and I
30.
provided receipts,
Та
about
на загальний
30 receipts
по сьогоднішньому курсу загальний
that amounted to
складає близько 40 тисяч, 490.
$42,490.
Тобто це половина.
This is a half the sum that I
Інколи я не
paid.
встигав оплачувати в
Sometimes I couldn't observe the payment timetable,
за наявності коштів я проплачував.
and whenever I had finances, I would pay 10 to 20,000 hryvnia.
Okay, thank you. Now I would like to go to another questions, and these are related to the property acquired in essence on the assets of your brother. And I have in mind three types of property. It's a family residential building, apartment, and Kia Sportage. Due to the family residential building, it is some questions remained because you said in your explanation that you use this family residential building also for spending some holidays and weekends. Yes. This residential building in Fontanka village is used by your mother, owned by your mother, not used, but owned by your mother. And you explained that the main financial source of the construction was your brother's saving from his working contracts abroad. Yes. And also, initially, you explained that your contribution was approximately about 1,000 or $1,500 of dollars periodically from your salary from 2018 until 2020. Is it correct?
Дякую за запитання. Дозвольте
Thank you for this question. Let me state that we are talking not only about a building in Fontanka village, but it's a building that for 5 years we have been constructing in our family with our own resources. So we are 3 brothers and a father. Some works were done by hired employees. At other times, we did works by ourselves. And I also explained that I participated whenever I wasn't busy at work. I helped to.
I would like to interrupt you. I am asking about your financial installments, not about your physical work in the constructing procedures.
Так, от саме цей період.
Yeah, exactly. So at that period, in 2017 to 2018, I also contributed financially. I would buy construction materials and I provided you some receipts because I didn't keep all the receipts. And the general sum for the construction, the value of the construction, 5-year construction, is $5,000 to $6,000. And in 2017, I spent $2,500 $2,500. And 2017-2018, and about 3,000 was used to electrify the building. And there is a video where I assemble the wires, and I am saying on the video when it was done.
You are saying that your investment was approximately 2,000 euros, not euros, dollars, and nevertheless, the electricity installment was approximately $6,000, but they are split it by another investors.
Я уточню, якщо можна.
So I will clarify. In 2017 to 2018, it was about $2,000, and I submitted receipts and proofs. And if we take the whole period from 2015 to 2020, when the building was being constructed, over that period, the general sum was $5,000 to $6,000, and some of it is proven, other is not.
Also, it is interesting for us. Could you explain why the house was registered to your mother's name, rather not in the name of the person who made most financial investments? I mean, to your brother's name.
Clear. Thank you for this question. In 2015, my mother sold her inheritance that was located in a different village. She got money. It was an advance payment at first, because those inheritance documents were registered by the end of 2019, and my mother wanted to buy a land plot in order to build a house, and therefore the land plot was registered in my mother's name. And to register an ownership right to build a house, we needed to have ownership to the land plot. So the one initiating the construction needs to have the right to the land. And over the time, circumstances changed. After using the money she got from selling her inheritance, we only had foundation and some bricks, and we couldn't move further. In a family council, we decided that we will construct a house for parents. I had 2 children back then, at that time, and I could help both physically and in part financially. My brother, who's a seaman, he had a certain experience and certain savings abroad. So step by step,
I understood. The owner of the land plot was your mother, therefore you registered the house also on her name. Nevertheless, the investment was a big one, was made by your brother. And your physical.
Yes, correct.
Another property also acquired essentially on the investment of your brother is Kia Sportage that was registered to your mother and gifted to you, and also the apartment in Sakharova Street where you lived from 2016 until 2020. This apartment also was acquired on the funds of your brother, but was registered to your mother. Yes.
Yes.
So then you explained to us that during family discussions aimed at preventing future inheritance disputes, the parents decided to distribute family assets during their lifetime in such order: to brother Ihor is Sakharova Street apartments. You receive Kia Sportage, and another brother the family house. How can you explain for just a general person such strange mechanism that all investments made by your brother was divided as inheritance into 3 parts to all of you?
Дійсно, дивіться, дякую за запитання. Це дуже таке важливе запитання.
Indeed, thank you for this important question. It's an important question for the society to understand. Actually, these purchases were made during a period of time. The first one was investment into an apartment from the stage of the foundation. So first there were investment rights in 2014, if I'm not mistaken. My brother explained me that in 2014, so it was before the purchase of the land plot by my mother. In 2014, he already paid out, or in 2015, he partially paid out
I'm not
this apartment.
asking about the history. I'm asking about the situation when the money of your brother is distributed or divided into 3 parts, more or less maybe equal to 3 brothers through the parents. What is then the basis or reason for such action?
Дякую.
Yes, thank you. Each of my brothers have their own families. And each of my brothers also had a duty to their parents. It happened that my seafarer brother lives abroad, so he could not look after the parents. That's why that object in the village of Fontanka was for the older brother as the person who is looking after the parents. He mostly lives there for the most period of time, and he's looking after the parents, especially now because our father has huge health problems. I will not name them, but I provided you with respective documents from which you can see that the situation is not very good and the problem is quite serious. With respect to me, it was decided at this family meeting, so to say, that I also took part in the construction of this house, parental house. And that's why, since my brother in 2021 bought from the auction in Korea this car that he was supposed to send to Ukraine, they decided that in order to somehow reimburse those funds or to express gratitude for my help, they decided to give this car to me. Back then, its value was not as declared.
I understand the sense that you both brothers were reimbursed by your third brother for looking after your parents and for making some additional works in the construction. Yeah, thank you. So now the last block of my questions, because we are lacking time, is related to your wife's income. And as we see from your declarations and the materials provided, your wife is lawyer and is self-employed lawyer since 2017. Yes, and you said that she has no income or no big income because she has approximately 3 or less cases per year. But if we check the register, we see that it was more than 3 cases, especially in 2018, 2021, 23, and 24. It's 4 or 5 cases per year. But nevertheless, there are no actual income, but she is paying annual expenses related to maintaining her legal practice amounted to approximately 20 or 25,000 hryvnias. while the income is lower than that. How can you explain this?
Дякую за запитання.
Thank you for your
Я
question.
хотів би пояснити, що
I would like to explain
того, що дійсно в нашій родині
that indeed in our family, during this period of time of over 10 years, the main source of existence of the family has been my salary. And from 2019 and 2020, that income has increased substantially. And we started even making some purchases, more or less. And we also had this opportunity to invest into our apartment that we have been dreaming of, which has not been constructed, and we were left without an apartment. So we have 3 children. My wife is, since the moment when we moved from the city of Donetsk to Odessa, she has always been looking after children. Back then they were young, 2 kids, and now we also have the smallest child, Victoria, and among other things, my wife is paying more attention to that.
I propose the answer. So you indicate that you pay from the family budget this fees because you want to maintain wife's status, yes, as legal advice or legal employer.
Так, дійсно,
Yes, indeed. In 2021, 2022, personally, I paid that unified single contribution because the war started, but my wife didn't have income. And especially given that she was evacuated, so I paid that fee, but not every time I'm paying that. She had some income. And these expenses that she bore, including taxes, that's partially from some income that she got because she did not have all the pro bono cases. After all, she has some cases on a paid basis.
Yes, but not big one. Yeah. So you provided us the credit contract of your wife from 2025, and it is mentioned there that the average income of your wife per month is 30,000 hryvnias. How does it correlate with this answer that she has no big income, but for credit card it was indicated that she has stable income of 3,000 hryvnias?
Я вибачаюсь, однак цю
I'm sorry,
інформацію
but this information was informed by my wife. I did not provide this information because I did not know that that amount was given in that credit agreement. But I would like to say that if the person had 30,000 hryvnias per month, then she would not be buying her phone on credit, but she bought it on credit because we got divorced and she bought it on credit, actually, because she didn't have money to buy it in full. She took half of the amount on credit and she paid the half of that amount on her own. With respect to the specification of this amount, I did not have that information because it was 2024, if I'm not mistaken, and back then we just or early 2025.
Начало 25 року, да, бо ми
Yes, the beginning of 2025, because we remarried in mid 2025.
I am asking about the information provided by a wife to the bank that she has permanent income of 3,000 hryvnias per month.
Дякую, я зрозумів, що ви саме
Yes, I understand that you are asking about that, but she concluded that credit agreement back when we were not married yet. But I didn't even know that she mentioned that information to the bank. Upon your request, I asked her to provide this agreement. She provided that, but I did not have any intent to conceal information about her income, and she didn't have that intent either. But I would like to draw your attention to the fact that she took this credit for a very basic thing that she didn't have back then. That was a broken phone, and she bought a new phone on credit. That's not. That's a very low level of income when a person is buying a credit, is taking a credit for a phone.
So Nevertheless, I think that your answer is not explaining the information that the bank was provided. But I am stopping here because I'm out of time. And
Thank you, Gabrielle. Any other questions on this side? Mary? Norman? No? Back to you, Mr. Chair.
Пані Надія.
Madam Nadia, please, the floor is yours. Thank you. Partially, I would like to continue some questions in continuation of Madam Gabriella's questions, and I will also have a separate block of questions that has not been analyzed yet. With respect to the income of your wife, again, from her attorney's activities and from her legal practice, as Madam Gabriella has emphasized, I also paid attention to some inconsistency in your explanations that you were providing to the PCAE. In response to the question dated February 26, you actually said that your wife did not have significant income. Her clients were mostly friends, neighbors, mothers of children attending the kindergarten or school. So mostly your wife was providing legal aid pro bono or for some very small payment. But at the same time, while answering to the questions dated March 7th, when we were discussing your declaration dated for 2020, in particular, in your declaration for 2020, you are declaring that your wife got income from independent professional activities in the amount of 58,795 hryvnias from your mother, the source of income. There was the question about the source of income. You said that you made a mistake because actually the source of income was your wife who engaged in independent activities, but you also emphasized that indeed that amount was paid by your mother because your wife was representing your mother in the respective case in court. So, as far as I understand, especially if we look at your mother's income, 58,795 hryvnias, that's a quarterly income of your mother approximately. So mostly, in all the other cases, your wife was providing her attorney's services pro bono, but in 2020, she concluded this agreement with your mother, and your mother paid her this amount. Is it correct? Thank you for your question, but I would like to follow up a bit. Indeed, in the declaration that I was filing in 2020, there was made an error, a mistake, and I admit that with respect to the source of income of my wife. And I declared only one of the sources of income, my mother, because back then the software was asking that. In fact, I had to declare my wife as the source of income for herself because she is a self-employed person. But my mother was one of the clients, and my wife had several clients back then. I could not declare all the clients because I didn't know them. Okay, I understand your position now, but I'm referring actually to your written explanations, where you clearly said that, yes, you made a technical mistake, but you specified the client, your mother, who paid for the services provided. Okay, again, with respect to the income of your wife and the assistance of your brother, in the materials of the dossier, in particular information provided by the NABU that you've looked through, it is said that your wife in September of 2023 crossed the border together with your daughter, and she returned in December of that year with 2 children. So she gave birth to your daughter, another daughter abroad in Canada specifically. According to information of the declaration for 2023, your wife's income was 0. Your income was also quite it was declared, but you provided an explanation that everything related to expenses on tickets for your wife and two kids, their stay there, their stay in the hospital, probably again. All of that was paid for by your brother? Yes, thank you. Let me explain that. I would like to clarify that my wife went to Canada with the help of the program that was provided by the government of Canada to Ukrainians. And for that, I'm really grateful to that friendly country. And all the money related to medical insurance, all of these funds related to the stay and giving birth were borne by the government of Canada. My wife did not pay anything. And even for items for the children were given after her hospitalization. Did you declare that in your assistance in your declaration? That the assistance, as specified in the NACP's explanations, that assistance was sort of charity assistance, and it was not supposed to be declared. That's why I did not declare that. And which part of funds was spent by your brother? My brother actually was not spending anything on her. He only I bought the tickets. That was the most expensive from this trip. I bought return tickets for them. The brother only allowed them to live in his apartment that he was renting. And I provided the rent agreement, and the period fully coincides with the period when my wife was going abroad. And the rent was indeed back then. He was just on a trip, a business trip, and they lived there a bit in his apartment, maybe about a month. Okay, thank you. In your written explanations, you did not mention that aid from the government. That's why I had this question. Now let's move on to another block that I would like to discuss with you, and that's actually in response to Madam Gabriela's questions about the qualities that you have would allow you to be a judge of the anti-corruption court, and you said compliance with requirements of the law, rights of parties to the proceeding, compliance with the procedural legislation. And in this context, I would like to ask a question about you being brought to disciplinary responsibility in 2018. In particular, by decision of the first disciplinary chamber that was later on upheld by the High Council of Justice, you were brought to disciplinary responsibility. If briefly, please correct me if I'm wrong, you were considering a case on division of shared property of the married couple. There was imposed arrest on the vehicle. After that, the third party submitted an application on cancellation of the interim measure for this vehicle, saying that that car had been sold and that the person who is now the real owner of this car cannot use it. They asked the court to quash the ruling on the interim measure. You did that, and then as a result of the examination of the materials, it was quashed by the Court of Appeal, and then the disciplinary chamber and then the High Council of Justice specified that with the materials of the disciplinary case confirmed that the judge did not comply with requirements of the procedural legislation with respect to the notification of the claimant. So there was made a significant violation of provisions of the procedural legislation during the administration of justice, which made it impossible for the parties to exercise their procedural rights and duties. These violations that took place because of improper notification of person one, that is wife, was made because of negligence, even though summons were sent, but they were sent to address that was the address of the ex-husband, even though the case materials contained information about the actual address of person one. And again, I would like to emphasize that the High Council of Justice, while considering your complaint, after all, confirmed the significance of the violation of the procedural law. provisions of the procedural law. Can you please briefly respond to that? If you allow, I will explain. As I've mentioned, that's indeed that was the lesson, thanks to which I could assess and further on make some conclusions for the organization of work. I really regret that this situation happened in my practice, and every time when I'm taking a part in the competition, I again and again think about that, and I really regret about the situation, but I fully respect the decision of the disciplinary chamber and the HCJ regarding that. I do not want in any way to shift my blame, but I would like to explain the mechanism of why the situation happened, because I've explained that in my explanations. I'm sorry, we do not have time. We have information. We have the decision of the High Council of Justice. He provided this information. But after all, I would like to emphasize that the final decision under your complaint is still that the HCJ confirmed the decision of the first disciplinary chamber and left it unamended. Can you please be concise? If briefly, then consideration of this category of cases lasted for 2 days. That's why I provided to the representative summons to be sent to other parties to the proceeding. He returned the summons, like there was said, refused to accept it. When I signed that ruling, and in a month later, this person came and said, I did not get anything, and I did not refuse to accept it. But the situation was there that some other person mentioned in the summons refused to accept the summons, and that's why I again addressed law enforcement bodies. There was initiated the criminal proceeding with respect to the provision of inaccurate information by this representative. There was initiated the criminal case with respect to him, but that does not release me from responsibility, even though because the court is obliged to summon the parties, and that's why after all of this situation, I checking everything twice, 3 times. Maybe that's also entails longer terms for the consideration of cases, because the post is returned incorrectly. Sometimes post employees fail to provide any information. That's why it's impacting the course of the case consideration and the terms for the case consideration. But of course, it does not release me from responsibility. That back then I took the decision and I could not amend that. But that person came and said that it was not her and she did not refuse to accept the summons. So that was a coincidence of some circumstances and some moments. Okay, thank you. Understood. At the same time, in a couple of years later, in particular in 2022, with respect to you, Odessa Court of Appeal on November 17 of 2022 adopted a separate ruling which established a violation by a judge of Malinovsky District Court of Odessa, Leonov, requirements of the procedural law. The decision says that the president of Malinovsky District Court of Odessa should be informed that for the discussion of the general meeting of judges and adoption of respective measures in order to prevent similar violations in the work of the court. You challenged that ruling again, and the final ruling of the Supreme Court, consisting of the Cassation Civil Court in 2023, was recognized this ruling as compliant with the law. The violation was that you were considering the case upon claim of the Fund of Social Insurance Management Board with respect to recovery of unsubstantiated funds. And then the management submitted a motion on termination of the proceeding. You did not respond to that motion at all. There was no court decision regarding this motion, and that became a ground for the adoption of this separate ruling. So, the fact that you are saying that after the disciplinary complaint in 2018, you did not have any remarks regarding your work, that subsequently you complied with requirements of the law, but still, in 2022, you still made this violation. Can you please also briefly explain that? Thank you. I would also like to explain here the role was also played by the attempt to counteract the delay of the case consideration by the party, because I had that proceeding in my case, and the fund was supposed to be liquidated by the end of the year. And this way, they were delaying their case consideration by submitting, after 6 months of the expiration of the preparatory proceeding, this motion on termination. Why they didn't submit that motion during the preparatory court hearing, it doesn't mean. But I made a conclusion. Maybe that was my psychology while taking this decision, that the parties, through all possible means, was delaying the case consideration because there was no other evidence. Did you respond somehow through some procedural document to this motion? No, that's the mistake that I'm admitting as well. I was supposed just to keep it leave it without the consideration. I mean, this motion, without any justification as to why they submitted to that in 6 months after the end of the preparatory hearing. But I adopted the decision on the same day. Now, on denial in satisfaction of this claim. And the Court of Appeal also upheld that. But they responded in such a way because, indeed, the motion submitted by the party has to be considered, because that's the principle that each party has to be heard by the court. Thank you. We understand your point, and we understand that you did not respond to that motion. And that became a ground for this separate ruling. We have appeals from CSOs. We've discussed some issues already. Some of them concern some mistakes in the declarations. Due to the lack of time, I believe it's not necessary to discuss them in detail now. Do we have a question? Yes. Good afternoon, Koliush, Commission member. I would like to clarify. When you were answering the question about Article 75 of the Criminal Code of Ukraine, release from the responsibility, you specified the possibility to change the punishment. I meant that for the anti-corruption court and the category of cases that are considered by it, the state made some reservations that during the conclusion of the plea deal, it's possible to move away from the sanctions envisioned by means of imposing the punishment. Not real one, but determination of the fine. Lower or higher threshold? Not higher and lower threshold. I mean the substitution of the real punishment with a fine, with another type of punishment. And that's envisioned by Article 75 of the Criminal Code? No. I was telling not about the Article 75, but about the law. A release from responsibility as a novelty. You mentioned that you know about.
Правильно я розумію, що там можливо
Do I understand it correctly that it's possible to replace the punishment with a penalty, with a fine there?
Можливість там передбачено в статті 75
Article 75 stipulates that,
відбування реального
let's say,
строку.
technically speaking,
Щодо заміни штрафу, це
it can be a conditional serving of a sentence.
правильно.
So you are talking about a different article. Okay, thank you.
Будь ласка.
Добрий день, питання буде стосуватися.
Hi, my question is regarding the practical assignment
Складали. Є
that
фраза,
you
при здійсненні юридичної кваліфікації
did
кримінального правопорушення
when
проступку суд враховує
qualifying
Верховного суду, згідно якої
an
суд
offense.
неодноразово
The
наголошувалось,
practice of the
що закон
Supreme
про
Court
кримінальну
was
відповідальність
used
має
that
застосовуватися
says
до
that
редакції на момент вчинення
criminal
кримінально караного діяння.
punishment
Станом на момент вчинення діла
needs to be applied
яка і підлягає застосуванню.
in the
Суд також
version,
враховує релевантну
according to the version of the law,
відповідно до якої
effective at the time of the offense.
принципу юридичної визначеності, який є одним із складових частин
And
принципу.
legal
А відповідно суди мають застосувати закон.
certainty is one of the principles that is used in order to qualify legal relations. Do you believe that criminal law that came into effect after the offense was committed can never be applied to this offense?
Загальний випадок
So I cited the general rule that the offense needs to be qualified by the law effective at the time of the offense. But there are also exceptions to this rule in cases when the disposition of the article is modified or the offense is decriminalized. Then other norms can be applied in case they came into effect later. So I described the general rule and I haven't mentioned the exceptions because it was truly a stressful experience and I managed to transfer the basic idea and the order of law application. Ruslan?
Олександр Степанович, член комісії Мельник. Щойно під час співбесіди ви зазначили,
The Commission member Melnik, you just mentioned that you were using AI tools a lot.
Чи визнає допустимим використання штучного інтелекту суддями?
Is AI, can AI be used by judges under the law? So the current version of the judges code of conduct does not forbid the judges to use AI other than in matters other than consideration of a case. Today we have an opportunity to use these tools and therefore I am using them. So the current version of the judge's code of conduct believes that it is admissible to use AI tools on certain conditions. What are those conditions? On conditions when a judge does not delegate his functions to the AI tool and administers justice themselves, when it is necessary to proofread the text for mistakes. Okay, thank you. Any other questions? PCA members, any other questions?
Yes.
Thank you. I just want to clarify two more things regarding the 10 cars that were acquired from the Korea in the period of 2016 and 2024. First of all, in your explanation, you said that these cars were damaged and repaired by your father and then used for personal needs. How can you explain that purchase and selling of these cars in 4 cases differ only in 1 month?
Я хотів би уточнити лише
I
ту
would like
інформацію,
to
що
clarify
особисто я ні разу не
that
використовував ці машини, і жодного
I haven't
на
used
них
those cars
я не маю. Це машини, які
at all,
брат Богдан
and
привозив,
these are my cars that my brother Seaman
ці машини привозили
brought,
з
and
фірми
he would
товариства,
deal with
приводили
them.
з
They were brought
вид, який
to
дозволяє їх
Ukraine, they were repaired,
моїм батьком та братом.
and my father and my brother
But you
used them.
explained that were used for personal needs, but it seems that if the acquirance and selling date differs only in 1 month, is some kind of business, no?
Я їх жодного чином не використовував і не міг такого
I
написати.
didn't use them, and I couldn't even write that
Дійсно, він коли приходить з рейсу,
So my brother, yes, indeed, when he comes back from work, we use them, and he would carry cement, some construction materials on those cars, in those cars. They were used for more than 10 years before. They could be used in any way. And after we repaired them, we could sell them.
Any more questions on this track? No. Thank you, Mr. Chair.
Добре, дякую. Пане Олександре, вам надається можливість звернутися до комісії.
Alexander, you've got an opportunity to address the HQCJ and PCIe members in order to state any facts that you would like to, and please be laconic. I would like to thank for this opportunity to take part in this competition. It is a possibility to boost your skills, and I would like to wish a good day to all the participants of this meeting. Thank you for your participation. Your interview is completed. We shall have a